Hi, this is Erica Norton, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a law firm out of the Worcester area, and it is a family and real estate law firm. She and her team are amazing at what they do. And today we're going to talk about something that is super important. We are going to be talking about divorce and wills. And you may think that it's none of your partner's business once you're divorced, but there could be certain things at play, and God forbid you forget to change your will and then you die and your ex gets everything. Am I right? Am I right, Nicole?
That's certainly an option.
I actually have certain situations in my family where someone had bad blood with their brother, and their brother was married but never changed his will. And I think his wife passed away. He never changed his will. So the very next of kin that was alive got it, and it was his sister, and they hated each other. And so I'm sure he was rolling in his grave.
There are so many stories where that exact same thing happened. So you really got to pay attention to that because, we all think about, okay, well, all this stuff is going to happen. And maybe there is a clause in there in the divorce that says you're not entitled to it, but a lot of things can happen between now and then. And again, what if it does leave you out and you're entitled to something? So let's talk about all that.
Okay. Well, so I guess let's talk about some of the reasons you would want to change. I mean, are children the only reason you would want to really make sure that you had an updated will?
No.
No.
Um, the simple answer is you want to update your will because you want to you got to look at it every 5 to 10 years. And I say that because it's really every 5 years, and it's really shorter than that depending on what's going on in your life, but at least every 5 years because things happen. People that you left in there that are either executors or they're getting something, they died, they pass away, you hate them now, whatever the case may be. So first start looking at it. But two, you got to make sure, is it pertaining to the children? Is it pertaining to your wife or ex-wife? Is it pertaining to assets? So all of those things you're going to be looking at because those are all things you want to make changes on or consider making changes on.
Well, what's the first step, do you think? I mean, you're looking through it, and you're trying to consider who gets your stuff, and some people get remarried, and their kids are mad because now all of a sudden the new wife who knew him for a minute gets half of a huge estate. I mean, you must see that happen all the time too.
Well, not only that, but you have the people that get remarried and go, "Oh, well, my children can take care of themselves. I'm going to leave everything to my new wife, and I'm not going to leave my children anything." So again, we have to talk about what is each party's elective share. Does a spouse have an elective share? Do the children have elective shares? And it all depends on whether or not they're an intact family or not. So first off, we need to know what the law is. So you need to come see an attorney to, one, figure out if the changes are in compliance with the law, two, how you can circumvent it, if there's a way you can circumvent it, and three, most importantly, whether or not it's accurate.
I mean, it is super interesting because I know when we put my will together, it was before I was with my current spouse. So, we did our prenup to where it says, yeah, he gets X amount and my daughter gets X amount, but we still haven't gone back and changed the will yet. That's on the to-do list. But there's still a lot of moving parts. So, I mean, what are the rule? What happens if you do nothing? I guess we could start there.
Well, if you let's say husband and wife married, they have children, they say, "Oh, we're going to be responsible adults. We're going to go in, we're going to get a will, we're going to get a whole estate planning." Great. And most likely they're leaving each other as the person that's receiving everything. They're also leaving each other the children. Great. Until you get divorced. Then not so great. Then the question is, okay, who's going to be the other parent or the other person that's going to take guardianship? Depending on the age of your children, do we need a trust for those children because we don't trust that your ex-spouse is going to allocate the funds accordingly because he's your ex for a reason, right? Um, Maybe we want to change it so that they're not getting any assets. So there's a lot of different changes that we're going to be looking at, but we're going to look at all of those. So what does it say right now? Is it appropriate? And how do we change it? Because again, depending on the age of the children, maybe they're 17 and we're going, we'll probably take the chances that we don't have to worry about this because we're going to live another year, right? And depending on your circumstances, might absolutely be the case. But again, a lot of times people will get divorced and their children are only 5 or 6. They don't ever think about it. And if the separation agreement doesn't say you do not get any assets, then you get whatever's left in the will. And if the will was done during the marriage, then they're getting everything, even though they're their next spouse. So it's really one of those things that you want to look at again, because those circumstances are going to change. So, from my perspective, anytime you get married, anytime you have another child, anytime you have a new significant other, anytime you get divorced, those are automatic look at the wills and update them. And then again, go back to every 5 years just because.
I mean, that's great advice. And I think it is true. You really need an attorney to tell you. I know it's so people make think it's so easy to just go on to some sort of a boilerplate document website where you can find apartment leasing documents and wills and marriage and all the stuff. And it's really bad because every state is different, every situation is different, and people have different things. Some people don't have any assets at all, and some people don't have children, and there's a lot of moving pieces. And gosh, when we did my will, you had 100 questions to ask me. You killed everybody I knew off, and it was quite a process. It was quite enlightening.
It is, and I think that's why that to me is a sign of a good attorney, and maybe it's just me being biased in myself, but the reality is that's what we do every day. Like we don't come up with these scenarios out of the clear blue. We come up with these scenarios because we've seen it, we've lived it, we've experienced it. So all of these things come about as a result of what we've witnessed in the courthouse or personally with our clients. So it's really one of those things that we have to go through the what if. Well, what if this and what if that, and kind of go through the scenarios because at the end of the day, you don't know what you're going to have, but ultimately, what if we have all these assets and they're given to the wrong person? Because that's not what you want. And the other part of this is people that don't even have wills.
And
That's
that's what
sometimes,
50% of the people or more don't actually even have wills, never mind updated ones.
and the only good thing about not having a will is then you don't need to update it. The question is whether or not you like your family or the hierarchy, because there's a hierarchy in Massachusetts, as there is in any state. But in Massachusetts, we will find your 20th cousin twice removed over blah, blah. Like they will go to the ends of the earth to find who is entitled to your money if you have no family. So don't think, oh, I don't have any family. If you have any assets, you should have a will. But, sometimes, I mean, the good thing with a divorce is you obviously don't need to update it. The bad thing with a divorce is great. If you have children, where are those children going? If, mom dies and then 2 weeks later, dad dies. Now this children's orphaned, and now you've got family members that are scrambling to claim custody. And if you had had a will, your directives would have at least been heard and probably granted.
I mean, gosh, it was really scary when we were trying to come up with who would get our kids, back then. And so, it's something that you might think is easy, and then you start doing it, and it's not easy.
No, and again, that's because there's 100 scenarios. Now I'll throw out a new one to you. So you're going through a divorce, but unfortunately, your spouse dies 10 days before the divorce absolute. Now you're legally married. Congratulations. So that decedent that really hated his wife and was ready to get rid of her, and by golly, they worked out a separation agreement and they worked really hard to make sure that she wasn't getting a penny. Now that he died, she's getting it all. So again, these are scenarios that come up in everyday life, and there's nothing you can do to prevent it.
Yeah, so that's a situation where you're kind of out of luck. Am I right?
Yes, you need to survive the divorce absolute to be deemed separated and divorced. And if not, then congratulations, your ex gets everything. And sometimes, I've had a scenario where my client had exactly that. Her husband died. And she's like, okay, great. Now I'll really find out what assets he had. And push comes to shove, years and years of litigation, we find out that he's got a whole hell of a lot of debt and absolutely no assets. But she didn't know it. And so now, she's going through all this and now she's spending money to chase bad money.
Yeah, I mean, and that's the problem when you don't know. Sometimes you pay to find out, and it's not good news.
It's true. So there's definitely a lot of circumstances that come up where, again, you're going to need to update it and look at it. But then the other part of that is great. Let's say you're a deadbeat and you're not paying your child support obligation. Just because that ex did update their will doesn't mean that they don't have a claim against the estate. They can then come after the estate to collect the past due child support if there's no life insurance policy in place, as was court ordered.
Hmm. And I mean, that's a really good point because the estate has to pay all the past due debts that they can figure out that that person owed. If there's money there, they probably have a priority over child support as well, I would think.
They absolutely do. And again, generally in a separation agreement, it's going to say that, this any debts that are listed herein that are not 100% complete, whether it be a division of a house asset in addition to child support. But those are going to trump. So again, as long as there's that debt outstanding, that's going to trump and that's going to take precedent. And they're going to be pretty much one of the higher ups. I can't say number one or two because the IRS and DOR are always going to be up there. But the other people underneath all of them, you're entitled to get your money back.
I mean, that's great news for the person that is owed the child support because children sure are expensive.
They absolutely are, and that's the reason why we do put in the life insurance policies because the ideal goal is you're going to pay it through life insurance. But sometimes people that don't pay child support don't bother to have a life insurance policy either.
Well, I mean, it's often written into the agreement, but like after years go by, people could just stop paying it. How do you check every once in a while on the life insurance policy?
Yeah, I mean, at some point it gets a little tiring. Like every year you're going to go, so show me your policy. Let me make sure it's in place. You have the right to ask that at any time, as many times as your little heart desires. But again, he's a deadbeat. He's not answering. Going job hopping. He's always working under the table. He's never going to do anything with his life. He's living in his mom's garage. Like, that person, right? Do you think that person's really going to bother to have life insurance? And even if you ask, do you think they're ever going to actually show it to you? So there is a time and place to ask for it. And it's frustrating being the person going, I just want you to follow the law. And I get that. But, would I say what the average time is? I would probably ask my ex every 18 months just to make sure it's in place.
All right. So everyone put that on your to-do list if you haven't done that lately. Um, Speaking of to-do lists though, like when you are revisiting your will, is there anything specifically that you want to check first? What's the most important thing? Um, and I know like what I found interesting when you were talking to me about this was that, if I don't have it written in, then my spouse will get half and my daughter will get half, right? My and so that's how that would work. They would just split it up automatically unless I do something to change it. So talk a little bit about any big rocks that we need to know about. Like, what do we really need to do when we're looking at these wills? And, really, how do we make sure the people that we want to get certain things will get them?
Well, again, it goes back to if somebody like your spouse can come in and say, they left everything to my daughter. Okay, great. He can go in and go, wait a minute, I'm entitled to my elective share. So his elective share, by operation of law, is the first $125,000 and half of the estate. That's what he's going to get. So we're going to start with that premise. And the children from a not intact family, which is basically so that's a family that you have a family, and then you have a child from a different family that you're currently in. And that's all it means. And so anytime you have this, step parent situation, you have a not intact family for all intents and purposes. And so when you have that, you also need to know that those children are automatically going to go, you're disinheriting me. I'm getting it. I'm entitled to half. So you have those situations where that's going to come into play. So first and foremost, know what the law is in your particular state, so you can really make sure that you're adhering to that. Or if nothing else, you're getting an agreement signed by the party that acknowledges that they don't want their elective share and they're opting out of it and they're doing so knowing and voluntary. After that, it really boils down to, again, who do I like? Who don't I like? Who am I not talking to anymore? Um, are they worthy? Maybe it's one of those things that you go, well, yeah, but they can now support themselves. When I first did this, they were struggling. Now they're a billionaire. They don't need my money. Maybe I'll give it to somebody else. So it's really kind of taking a hard look as to what is most beneficial for I guess your wants and your desires. But really looking at that, and the other part of that, of course, is who's going to be the financial person. So who's going to be the personal representative or the executor? Are they still financially trustworthy? Have they fallen on hard times? Have they really sat there and said, I'm struggling? And, oh, well, I'm going to use Peter to pay Paul. If they're doing that in their personal life, they're probably not the person that you want to hold all of your assets and then make the distributions. So you really got to take a hard look at those people and have their attitude change. Has their position or station in life changed that much that you're really now going, ew, I don't know that that's a good idea. Because if it has that hook factor, move on. Just saying.
I mean, that's a good point. And I know we did a prenup, and I know my new husband's uh, attorney was saying, why does she get 100%, but you only get 50%? And sometimes it's just like that because he doesn't have any kids. And so, my daughter would still get half. She was getting all of it before I married him. So, I mean, there's definitely going to be, it's not always completely equal, too.
No, and it doesn't have to be equal. And again, it's about knowing what the law is and knowing if I don't want to follow the default, how do I get out of the default? And obviously you would need to have an attorney to look at that to know what you need to do.
Well, I mean, this is very helpful. I don't think people do wills to begin with. I mean, a lot of people don't, and they absolutely should. And there's five documents that you really should have um, when you have a will, and it's like your your health proxy and your power of attorney, and you've talked about all of these documents that go with a will, but like even like you were saying, looking at the person and what their finances are like now. So the people with the power of attorney, it's great if you can give them a shot now while you're alive and you can watch over them, give them a little chance to see how they do if they have access. And are they going to try to do something sneaky now? Well, now that you can notice, let's just make sure that they're, honest. I mean, so there's a lot of things that you've pointed out that you should watch out for. And I think all of those points are valid. I mean, the will is really important. but some of those other documents are also important. And if you have a good attorney like you, Nicole, you really make sure that somebody has a well-rounded stack of documents that really cover you in all of those situations.
And I think you do. I need that because, like I said, at the end of the day, we've been there. It's called probate and family court. Guess what? The probate is what we're talking about. So I'm sitting in that court every day, and half the time we're talking about probate. We're not talking about divorces. We're talking about probate. And so you see what happens, and you see what happens when you don't have the documents because I didn't create them, and now I'm incompetent. And now everyone's fighting over who's going to be the conservator of my estate and take care of my finances and who's going to be the guardian and make these decisions. But I haven't talked to my family in 20 years. That's what you're faced with when you're doing it and you're live and you have a voice, but you have a voice that is now deemed incompetent. So you can't really articulate that, or the judge doesn't care so much about what you say because you can't write it down. So it's really about doing it timely and again, updating it because, maybe you liked them last week and you hate them this week.
I mean, and that's a really good point that you make because anyone who has elderly parents, look, we all know, like, once you hit a certain age, you start forgetting things. Hell, we all start forgetting things. I might forget some things now. Maybe I'm a little better in the morning right now. But when you're even older than that, I mean, it happens at different times for everyone, but you're slowly slipping away, and sometimes all of a sudden you're slipping down this slope, and you're being put in a Alzheimer's healthcare type of a facility where they're helping you with memory care and that sort of thing. And then what happens to all your documents then? Like you said, nothing that you say is really going to matter. So I mean, it's frustrating for the children, that's for sure, when they're trying to help you, but number one, they don't know where anything is. They don't know what your bank accounts are. They don't know what you have for assets. They got to go through, anyone that's had to move, they know that there's so much junk. And this is like a last minute thing. And so people are not prepared, and it is absolutely miserable for the kids.
Yeah, and I think that brings up one good point is that, you say they don't know what the assets are, they don't know all the stuff. Well, you know what? Unfortunately, when you pass away, sometimes it's harder for us to find that out nowadays anyways, because so many people are doing online banking, whether it be with your, just your bank accounts or your retirement accounts or all those other things. In the olden days, it was, hey, just get all the mail and now we'll know what they have. Not so much anymore. So I'm encouraging my clients that when they are drafting these documents, have a separate thing that they put, whether it's with the will or somewhere else, it says these are the bank accounts. And I don't need to necessarily know the bank account numbers, but I have 3 TD Bank accounts. I have 2 Bank of America accounts. I have 3 Santander accounts, whatever it is, so that I can articulate and go, oh, Santander, 3 of them. Oh, wait, these are only checkings. Let's see. There's a total of 3. I'm good. So you really can kind of gauge as to where that money is, because nowadays, sometimes, unfortunately, that money does go into findmassmoney.com because nobody knows that, they know that you died. They know that there's no activity in the account. They're esketing it to the state and going, figure it out. And at the end of the day, that was an asset you never knew existed because there was no paper trail.
I know. And look, so many people are doing Cash Apps, Venmo, and that they might have balances in there. They might have property you didn't know that they had, and it's some little fishing cabin in Maine. I mean, there are so many things that people could have, and just, do your family a favor and make sure that, people know what that stuff is. And um, I think this is a really useful interview today because you just don't think about it until it's too late sometimes.
Absolutely. And I think, like I said, that's a big point. But, give us something to work with, give us something to document. I always say document, document. That's what I'm still saying, document, 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 because it's helpful. I mean, it's going to save you and your family thousands of dollars every year.
Well, really appreciate you bringing this up today, Nicole. I think very valid, and everyone should make an appointment with you within the next week just to discuss this stuff because it is so important. And I know that probably, oh wait, what percentage of your clients do you think need to change their wills, but they haven't?
At least a third that I know about.
Yeah, okay. Well, that makes sense. But yeah. So thank you so much. Thanks everybody for watching today, and hopefully you go out there and get your documents straightened out as a result of this. And thank you so much, Nicole, for coming on. It's really amazing that you are so generous with your time and your information.
Thanks for having me.
You're welcome. And thanks everyone for watching.